what's indiscriminate violence? We looked at, I said earlier that the big tension really was between individual threat and indiscriminate violence. So once you look at the laws of war, it seems pretty apparent that indiscriminate violence is military action that fails to distinguish between civilian and military targets. Terrorism atrocities in general, tend to do a fairly poor job of distinguishing between military and civilian targets. And the American Marines hardly covered themselves in glory in Fallujah a couple of years ago. So you could say there's significant evidence of the kind of violence that's been taking place in Iraq, for example, as being indiscriminate in terms of a failure to distinguish between civilian and military targets. Final point of this session is what is an armed conflict? And two forms of armed conflict, I mean, no doubt all forms of armed conflict, both internal and international, are covered by Article 15C. What is an armed conflict? Well, the best decision on this is a decision of the International Tribunal for Yugoslavia, in the case of Tadic, contemplated 5 of my notes. And in Tadic, the criminal law judges say that we find an armed conflict exists whenever there was resort to armed force between states or protracted armed violence between governmental authorities and organised armed groups, or between such groups within a state. International humanitarian law applies to the initiation of such armed conflict and extends beyond cessation of hostilities until a general conclusion of peace is reached, or in case of internal conflicts, a peaceful settlement is achieved. So it's very notable there that firstly, the law of armed conflict would appear to apply not only during the heat of the fighting, but until such time as you have a secure end to the conflict attested to by signing peace documents. But also that the test is a fairly simple one, that you have resort to armed force or protracted armed violence between governmental authorities and organised armed groups. And if you look, for example, in Iraq, at sources like all the expert witnesses who gave evidence to the Select Defence Committee on Iraq back in early 2007, they put together very impressive testimony about the extent to which the insurgency in Iraq was not simply a few isolated insurgents, but rather very strongly coordinated armed forces, some no doubt with parliamentary representation in the Iraqi transitional government, and others with strong links to the Iranian government, or forces in Iran.
Now what I'm attempting to do then in this chapter is to situate more precisely the place of the refugee and of international refugee law in the purported transition of Europe, not from a pre-modern to a modern state of existence, which of course was the time shift that migratory settlements during the Age of Discovery sought to bring about, but adopted, for the purposes of the argument, the rather grand claims that some European constitutional lawyers make, the transition of Europe from the modern to the postmodern. And I'm sure that most of you have heard of scholars in particular talking about the European Union as being a postmodern political form, as being something, a form of governance that has no precise historical precedent. So the transition that EU is making is from the modern to the postmodern. Now, what is the place of the refugee in this? Now, I suggest that that place is to be found in the contemporary staging of the opposition between the progressive and the reactionary, or as Etienne Balibar would have it, the universalistic and progressive, and the particularistic and primitive. And it is in this particular dialectical opposition that I think is significant in seeing how the refugee is viewed within the EU, and it is an opposition that has constituted and authorised virtually every sovereign entity at the most crucial moments of its emergence, and is one that is constantly invoked, I suggest, by the European Union as it seeks to separate itself from the old order of the arrangement of nation-state. So we hear constantly talk of the vicious circle of violence. Those quotations, I think, demonstrates how the dialectic is conducted at the discursive level. But my principal focus of inquiry here is on how specific social groups, such as the refugee, are captured in the dialectical opposing of the savage, the civil, or the primitive or advanced state. And such groups are constructed by the same discursive practices that figure the dialectic as uniquely representing the now utterly discredited old order. So the refugee enters this debate about the progressive Europe, the progressive new Europe, and the regressive old Europe by being positioned as being representative of the old discredited state. That, as I suggest, is the place of the refugee within the European Union, seemingly stubbornly attached to the old modern world and antagonistic towards the new post-modern Europe. Now, of course, for those of you who are familiar with some of the debates about, the academic debates in particular about the place of the refugee, I think you'll be familiar to some extent with that argument. Many others before me have argued that the European Union asserts itself against certain excluded others. And that's the term that's often used. And within that grouping, the refugee occupies a special place. The refugee is more than just one of Europe's others. That is more than one of a number of identifiably non-Europeans against which a default definition of Europe is being constructed. She is, in my view, the human remnant in the European Union of the nation-state form, the principal signifier of the bankrupt old order. And what I'm about to say is very important for the thesis. The only refugee who can come to the European Union, secure in the knowledge that a safe haven exists, has been endowed with all the negative attributes of the old. The refugee is necessary to the European Union, but necessary only insofar as she operates to remind all of the chaos that threatens if the new order is not embraced fully. And thus the old bankrupt condition of the nation state and the refugee are inexorably linked.
I started doing some volunteer work with failed asylum seekers in Newcastle upon Tyne, which was very hard work. I don't still do that. I found it very difficult indeed. What I have started to do is instead sort of divert my energies towards writing and speaking, and generally trying to do what I do with papers like what I'm going to give today. I did write something on credibility before. I actually wrote it in April 2006. It only got published just before Christmas. So what I'm in the process of doing now is updating that and looking at a few more things in relation to it. That book chapter which I put up there argued that the techniques used to establish credibility combine in such a way that the active construction of knowledge by the immigration judge is denied. And I think all that is important because we see how the construction of knowledge is so important to these asylum applications. We know that most of them are rejected. The figure is somewhere around 80%. We'll have a look at this, the most recent quarterly statistics. We know that there is what Jonathan Enser and company described as an agenda of disbelief in the decision-making process. Alexander Popovich, Popovich, okay. She points out that really it's about the state justifying its action in the face of the principle of non-refoulement. But we shift that into a claim right expressed as seeking asylum. The starting point, she argues, of the assessment in an asylum or non-refoulement case should be a hypothesis of non-refoulement and a duty of objective investigation imposed upon the state. Now that's perhaps idealistic, but if you think about it, that is what's happening in an asylum case. It's all about non-refoulement. Now the rest of her chapter makes use of a very extended metaphor. This is in Gregor Knoll's book on evidence and proof in asylum cases. The rest of her book chapter uses a very extended metaphor where she uses criminal procedures to represent aspects of the asylum process. Some of that's quite interesting, but I found it a little clunky. It did get me thinking about crime though. She uses rape as a frequent example, and I'm going to start off in the same direction. So credibility has a very pervasive role